Hello, and welcome to Understanding Law in Canada. Today, we explore the framework of our legal system, from its basic categories to its historical roots and court hierarchy. Let's start with Part 1, the four main categories of law. Law is organized into categories to handle different situations. First, we have substantive and procedural law. Substantive law defines our actual rights and duties. It is essentially the what of the law. For example, the rule that theft is a crime or that a signed contract must be honored are substantive laws. Procedural law, however, sets the rules for enforcing those rights. It's the how of the legal process. This includes the rules for how a trial runs, filing deadlines, and rules of evidence. Next, we distinguish between public and private law. Public law governs disputes between the state and individuals. Public law includes constitutional, criminal, and administrative law. A real-world example is a criminal charge brought by the Crown against an individual. Private law handles disputes between individuals or businesses. This covers areas like contracts, torts, property, and family law. For instance, suing a builder who broke a contract is a matter of private law. Part 2. Where do these laws come from? The origins of Canadian law. Our system is rooted in the 12th century rediscovery of Roman law at the University of Bologna. This became the foundation for the civil law tradition seen around the world. Canada actually inherited two great legal traditions, English common law and French civil law. English common law arrived through the Royal Proclamation of 1763 and was entrenched by the Quebec Act of 1774. It governs 9 provinces and the territories today. Upper Canada adopted it in 1792. French civil law, rooted in the custom of Paris, was preserved for Quebec's private law. It was codified in 1866 and exists today as the Civil Code of Quebec. This makes Canada bijural, using 2 distinct legal systems depending on the region and matter. For example, a contract dispute in Ontario is judged under common law, while the same dispute in Quebec follows the Civil Code. Finally, Part 3. How the Canadian court system is structured. The system is organized from the bottom up, ensuring every case has a path for review. Provincial and territorial courts are where the majority of cases begin. Above them, superior courts handle more serious trials and complex legal matters. This level also includes the federal court and the tax court for specific federal issues. Next are the appellate courts, which review decisions made by the lower trial courts. These include the provincial and territorial courts of appeal and the federal court of appeal. At the very top is the Supreme Court of Canada, the final court of appeal for the entire country. Its decisions are binding and set the ultimate legal precedent for all of Canada. A case can start in a provincial court, move to a court of appeal, and finally reach the Supreme Court. Understanding categories, origins, and courts helps us see how Canadian law fits together. I encourage you to keep building your understanding of this complex and fascinating system. Thank you for joining this session with ABI Education. I'll see you in the next lesson.